Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Recently, every legal pundit, every advocate, they have been discussing regarding the Bail Act as suggested by Honorable Supreme Court of India very recently. So this is in relation to Satender Kumar Antik. Satender Kumar Antik versus CBI 2022. In this case, two judges bench, Justice Sanjay Kishan Kaul and M.M. Sundaresh. So actually they have expressed their dissatisfaction or unhappiness over the current state of India's bail system or criminal justice system regarding non-application of the 41A CRPC notice. All these things they have discussed. Actually, Justice M.M. Sundaresh, he drafted the judgment. He is the author of the judgment. It touched so many cases, right from ADM Jabalpur, Sheila Barse, then so many cases he has touched regarding the personal liberty, all these things. So definitely, liberty is one of the fundamental rights of the humans. Constitution has given liberty. Article 21 says, right, though the state should protect the personal life and personal liberty of each and of every citizen except as per the procedure established by law. Right, now coming to the facts of the case, Satender Kumar Antik, he filed a case against, he is not an ordinary man, he is involved in the Money Laundering Act case, and a case under section 427 and 420 and 467 IPC were also booked against him that he prepared some forged documents. 420 is for cheating, 467 is cheating for the purpose of forgery. Of course, these offences are punishable up to 7 years imprisonment. Up to 7 years. This word you have to note. Up to 7 years imprisonment. Right? So in such cases, normally what you think that if the punishment is less than 7 years, you can give 41A notice. So you need not ask him to attend the court. You need not arrest him if you are satisfied that he will attend the court. After all, the very purpose of arrest is to see that the person is brought before the court, to see that the person appears before the court on all dates of judgment, on all the dates of adjournment. That's the only main purpose of arrest. That's why even in CRPC I have been telling you, the IO may arrest. Of course, we know in some lower judiciary, particularly the young magistrates, they say, police, why did not arrest that man, you are arresting this innocent fellow like that. They will be asking, they will be under the impression that arrest is a must. It's not. But normally, they will be asking. I have faced that question also. That's why I am telling you personal experience. Right. The court, in this case, so in the just touching point is this offence is punishable up to 7 years. So 41A notice can be given. You may be referring to Arnesh Kumar judgment. 41A notice below 7 years. If the punishment is below 7 years, but this is up to 7 years. Therefore, they have not given the 41A notice. Here, the Supreme Court opined that what is this? It shows that there is a scant respect for the human rights by the many departments. So indiscriminate arrests are so they are the indication of the colonial misconduct. And once again, are we going towards the police state? Ours is a welfare state, but still it is an indication that we are going towards the police state. So many judgments they have given already gets done, right? So law enforcement agencies, they make many arrests in violation of the basic human rights. And the lower judiciary, as just I told you, why they make the arrest is, so since I am a retired police officer, I have to express. So unless the arrests are there, there will be no maintenance of law and order. So definitely, if you leave a person with a 41 notice or following these things, normally we will be under the impression that he will be, once he is let free, he will once again commit the same offences and he will become the recidivist, and the other people will have no fear. The arrest brings fear psychosis in him as well as the neighboring locality also. That is the object. But Arresting merely at the drop of a hat on suspicion is not correct. So, of course, judges also normally in routine procedure they will be giving the so-called remands also, right? So, this practice of arresting the suspect at the drop of a hat should be stopped. And once again, we are remembered of the age-old saying of Justice V.R. Krishna here. He said, in the case of State of Rajasthan, Jaipur versus Balchand versus alias Balai, 1977, the basic rule is bail, not jail, except where there are circumstances suggesting that he will flee away from justice or he may create trouble to the family of the victims. Right. So, and this Satender Kumar case has now become the landmark case. Why? Because the courts opine that why doesn't the government go for the Bail Act? Why do they? So already in America there is a Bail Reforms Act in 1966 itself, whereas UK has got the Bail Act. So this will be appropriate. So there they think that bail is a right and jail is an exception. So the law says arrest should be rare, British law, arrest should be rare. Bail provision should be uncomplicated and electronic surveillance will be the novel model. Suppose if you release him on bail on certain conditions, yes, you can keep the RFID tag or you can use the RFID tag. Yes, definitely. In America it happens. So his movements will be under your control. He need not be in the jail. So such things, such developments should go in line. So therefore, ultimately to conclude, they have taken the assistance of the famous advocate Siddhartha Luthra. Ultimately, the Supreme Court gave certain guidelines in this particular case. Actually, I wanted to make a separate video on the guidelines because I have to tell it in the here. It will be appropriate for me to tell here itself. Right? The category of offences were treated as four. Four categories of offences were made. Category A, that is punishable with 7 years or less. Now the point has very clearly 7 years or less, up to 7 years also come. So category A, for this definitely you have to go for 41A notice. Category B and D, let us summarize. So they are offences punishable with death, punishable with life imprisonment or more than 7 years. So you need not give 41, arrest, and the court will take over the matter whether to give him bail or not. Category C, this is an important case. No doubt here the offences may be bailable, but they are special acts like NDPS, Narcotic Drugs and Psychotropic Substances, then Money Laundering Act or Unlawful Activities Prevention Act or Economic ED offences, all these things. So in this connection, you cannot use the 41A notice. So please remember, normally 41A not arrested, you need not arrest during investigation. And if you are satisfied that this man has cooperated entirely during the investigation, straight away you can file the charge sheet and send him to the court. Right? Please remember. So the procedure all of you know. Ordinarily in 41A notice, summons will be issued to him, and if he doesn't return a bailable warrant, then non-bailable warrant, then if he attends before the court, definitely some consideration will be taken. In the so-called category B and D, definitely he has to be arrested, he has to be physically brought before the court, then the court will decide about the bail conditions. So these are the, and please remember, interim bail also can be given in the category of B and D also. But anyway, as regards 41 is concerned, please remember Arnesh Kumar versus State of Bihar 2012 celebrated judgment. So anyway, the Honorable Supreme Court of India definitely they have opened a topic for discussion regarding the Bail Act of UK and the US also. And if the Bail Act comes into existence, there will be certain guidelines, and definitely everybody has to follow. But please remember, bail is the personal discretion of the judge that cannot be waived off. Right? Okay. If you know this much, it is sufficient. So please remember this Satender Kumar Antik versus CBI 2022 will become a landmark case as regards Bail Reforms Act, Bail Act is concerned. Please remember this. Okay. Thank you.